In this lesson, looking at family relationships, I want to just spend some time talking about the issue of same-sex marriage. Now, this is one of the issues that is seemingly probably regarded as one of the most important or one of the largest developments in relation to marriage law in England and Wales. So we're going to be going over and covering the final element of the definition of marriage as elucidated in the case of Hyde and Hyde. We noted already that marriages take place for life, that they're a union to the exclusion of everybody else, and that they take place between a man and a woman. This is, of course, a lot more controversial, especially given the growth of LGBTQ plus rights. So we're going to be talking about how that law has developed to this day, how the law on the concept of marriage has become more and more interesting in relation to where we now sit today on the law of marriage allowing for same-sex marriage. So, basic recap then, the case of Hyde and Hyde made this particular point. They said that marriage is the voluntary union for life of one man and one woman at the exclusion of others. We've talked already about the concept of marriage for life. We've also talked about the concept of marriage at the exclusion of others. This episode is going to talk about the part that is italicized here, which is the idea of it being between one man and one woman. So, the addition of same-sex marriage into law took place through a number of stages, and you'll be actually surprised, those of you who are growing up and studying law in sort of 2025, 2026, 2027, if you're watching these lessons all the way into the future, you'll be surprised at how late in the process this actually took. So, various governments involved in the process saw this as a balancing exercise. They saw this as a balancing exercise between the genuine rights that were believed to exist between LGBTQ plus couples, which obviously made sense, but also the concerns that were had in relation to the Church of England. Remember, marriage is traditionally a religious concept. It's a religious sacrament within the Bible, within Christianity, and so it needs to be balanced. This idea that essentially we want to keep the church happy, but we also want to make it available for same-sex couples to be able to get married as well. So the first step towards this sort of line of inquiry came in 2004, and this was with the Civil Partnership Act of 2004. So we'll get to the idea of civil partnerships in more detail in future lessons, but generally all this did was introduce the possibility for same-sex couples to enter into something known as a civil partnership. Now, a civil partnership allows for essentially same-sex couples to be registered as being civilly partnered. In terms of rights that were conferred onto civil partnerships, they were very similar, nearly the same as that of marriage, but the Civil Partnerships Act did not define this new relationship as a marriage. And this, at the time, in 2004 at least, was considered to be the sort of compromise that was necessary. The sort of compromise that allows for the church to say, well, we don't have to recognize same-sex marriage, but also it allows for LGBTQ plus people to be able to have something that is akin to a marriage, but technically isn't a marriage. Now, of course, you might think, well, what's the problem with that? But obviously, equality requires compromise, but it also requires a compromise on the part of religious institutions, in my opinion. And so, in this regard, this, while was a step towards equality, the fact that they weren't actually technically marriages meant that there is still difference, there is still discrimination in the law in this regard. So, really, we shouldn't be happy until an actual ability for same-sex marriage to take place actually is put into the law itself. And this comes in 2013 with the Marriage Same-Sex Couples Act. This was the next major development in terms of LGBT rights. It came into effect in March 2014 and allowed people who were in same-sex relationships to marry for the first time in England and Wales. And this was the major development. This was the one that was celebrated most extensively. and it is the one that allows for same-sex marriage to take place. Now, the next sort of question and debate that needed to be raised was in relation to how marriage ought to be dealt with when it came to trans rights, to a growing issue relating to trans identities and for individuals who identify as trans to be able to get married lawfully, and for this to actually be something that the law recognizes as well. This is, as you would probably imagine, a developing area. The law and medicine, as it turns out, is also relatively slow to catch up with the rest of society on this issue. But the introduction of the Human Rights Act, as well as a number of subsequent pieces of case law, brought the issue of trans rights into the fold when it came to the concept of marriage. This would essentially challenge, from a different angle at least, the one man, one woman dynamic. It doesn't challenge necessarily from the perspective of same-sex couples, but it quite interestingly challenges the dynamic of one man and one woman. And one of the cases that is really early that we can illustrate here is a case from 2003, the case of Bellinger and Bellinger. We looked at this when we discussed public law, but I'm going to go through it in this lesson as well. So the facts of this case was as follows. Mrs. Bellinger was a transgender woman assigned male at birth. She had been living as a woman for a number of years before she made the decision that she wanted to marry. She wanted to marry a man, okay? Now, according to the 1973 Matrimonial Causes Act, specifically Section 11, subsection C, a marriage would be void if the parties are not respectively male and female. Bellinger sought to appeal to the House of Lords, making an argument that the provision that is cited here in the Matrimonial Causes Act is actually incompatible with Article 12 of the ECHR, and so, as a result of which, would find a declaration of incompatibility under Section 4 of the Human Rights Act. It was held that it was initially suggested, should I say, that the marriage was in fact invalid. However, when we get to the case at the ECTHR, and the European Court of Human Rights, in the case of Goodwin versus the United Kingdom, it would be seen to be a violation of Articles 8 and 12 of the Convention to not recognise the validity of gender reassignment in the context of marriage. So it is a sort of bittersweet conclusion in the terms of this case. While the House of Lords did suggest initially that the marriage was invalid, when we think about how this kind of issue was brought about in the European Court on Human Rights, the case of Goodwin versus the United Kingdom made it clear that a violation of Articles 8 and 12 of the ECHR would ensue if it is not recognised that the validity of a gender reassignment when it comes to the context of marriage. Furthermore, we see the Gender Recognition Act of 2004. On account, among other things, of the Bellinger case, the government introduces this Gender Recognition Act, which allows for further recognition of trans rights in relation to all sorts of social issues. One such social issue includes marriage. Now, as I mentioned at the start of our discussion looking at trans rights, this is obviously a developing issue. The law is likely to change consistently and increasingly over the years that will follow, hopefully and continually with a Labour government that will take place, but we will see how this actually ends up developing in the future. But for now, that's just sort of an overview of the ways in which the issue of trans rights sort of incorporates into the family law question of marriage.